Yeah, so my name's Tanya. I'm a music-focused attorney based here in Portland, Oregon. I'm also a board member at OVLA. I started my legal career also here in Portland at a pillar in the independent music space and the digital distribution space, CD Baby. Some of you may be acquainted with it. After spending some years there, initially as an intern and later as in-house counsel, I moved over to Downtown Artist and Label Services, where I worked as Senior Director of Business Affairs, and that is what I currently do. So just a little bit more housekeeping before we jump into the presentation. This is for informational purposes only. It's not legal advice. I am a lawyer, but I am not your lawyer, and information conveyed in here is not legal advice specific to you and your situation. We're always happy to address general questions, of course, but if you have a specific inquiry about your particular legal issues, we ask that you please contact an attorney, and you can always reach out to the OVLA as well to be put in contact with an attorney. So today we will be going over copyright. We're going to discuss what is a copyright, what can be copyrighted, what works are subject to copyright protection. We're going to discuss copyright ownership, who the initial ownership is, and how ownership of your copyrights can be affected. Registration, infringement, both how to avoid it, how to recognize it, and what to do if your copyrightable works are infringed upon. And lastly, we'll also touch on fair use and the current AI impacts in the current copyright landscape. So with basics, what is copyright? It's really just a form of protection that's provided by US law to authors of certain works. While we're going to be focusing in on copyright today, it's helpful to understand that there are four main types of copyright protection. Or, pardon me, intellectual property protection: copyright, trademark, patents, and trade secrets. So copyright protects a fixed form of expression. So things like short stories, books, songs, architectural drawings, things of that nature. Trademarks are different than copyrights in that they protect the brand identity. So when you're thinking of trademarks, think of brands that you recognize, like Nike, Dr. Bronner's, Adidas, etc. A trademark is generally a distinctive word, symbol, phrase, or design that identifies and distinguishes the source of goods or services. The intention behind a trademark is that it represents the essence of a company and what its values are, and it acts as a shield against confusion in the marketplace because it ensures that customers can clearly identify and differentiate between products and services. Then we have patents. Patents generally protect inventions, so either a process or some sort of mechanical product. A US patent gives you the right to exclude others from making, selling, offering for sale, or using an invention or importing it into the US. But it's important to keep in mind that a patent doesn't grant you the right to make a process or invention. It just gives you the right to stop others from doing so if you have a patent on a process or invention. And then lastly, trade secrets. So trade secrets protect sensitive business information, and not every secret or not every piece of information is going to constitute a trade secret. It's much more specific. It has to be information that has economic value by virtue of being unknown. So the fact that people don't know about it is what gives its value. Also information that would create value by being shared. So if somebody were aware of it, they would gain some sort of economic value. And it's reasonably protected as a secret. If you have a trade secret and you go on TikTok or Instagram and you post about it, it's very unlikely to be considered a trade secret because you're not taking reasonable protections. And I know that OVLA has some other resources and articles available for other forms of IP protection. So if you're interested in that, just let us know and we can connect you with that information. So copyrights, what can be copyrighted? Not everything is subject to copyright protection. It has to be an original work that's fixed in a tangible medium and contains a minimal amount of creativity. Works that are generally subject to copyright protection include things like poetry, novels, movies, songs, computer software, architectural plans, and drawings. So there are three elements that are required for a work to be copyrightable: an original work of authorship, that's fixed in a tangible medium of expression and contains minimal creativity. So let's talk about original. At its very essence, original means that you have to have created it. It can't be something that already exists and you've copied and maybe modified a little bit or not. A work of authorship can include a wide variety of works, so it's not limited to just, written authorship as a lot of people might think about it. It's not just for books, poems, novels. It could also include songs, it could include dramatic work, so a play, images, audiovisual works, movies, etc. Only the original author has the original right to authorship. There are some exceptions here that we'll touch on later, such as the work made for hire exception, but for the most part, your general rule of thumb is that you have to be the original author to be able to hold a copyright. And then lastly, you can't just copyright data. So for example, you can't copy all of the addresses out of the phone book or data in a certain place and then expect that it would be subject to copyright protection if you don't do anything else with it. The next requirement is tangible. So tangible doesn't just mean that it has to be fixed in a way that you can touch it. It also means, something that you can refer to. So there's a couple parts in here that I want to break down. So fixed in a tangible medium of expression. Fixed means that it's not simply a transitory reproduction or showing of something. It has to be recorded in some sort of way. So for example, this presentation, since it's being recorded, this would be fixed and it could be subject to copyright protection. A tangible medium is something that you can either see or refer to. So it could include a sound recording, writing on a piece of paper, or written music. And I think basically the best way to think about it is if the medium allows you to take the work and then show it to somebody else at a different place in time, that counts as tangible as far as the law is concerned. But if let's say you're just talking to a friend and in passing conversation, you're discussing an idea that you have, that wouldn't be subject to copyright protection if it wasn't fixed in some sort of tangible medium of expression, because it's just a conversation between people. Lastly, creativity. So the copyright provides that in order for something to be subject to copyrightable, it has to contain minimal creativity. And the bar is really low here. It's not meant to require a high amount of creativity. So going back to my address book example, if you find a really creative way to organize the address book, then that might be copyrightable. Not necessarily the data that you've organized, but the way in which that you decide to organize and present it to the public. And I just want to emphasize that ideas themselves are not copyrightable. What's copyrightable is the expression of the idea. So just because you have an idea that is not subject to copyright protection, it has to be embodied in a work, in a tangible form of expression. Other things that aren't copyrightable, titles and short slogans and short phrases. For example, Coca-Cola, it's the real thing. That's subject to trademark protection, not copyright. And then also anything that's subject to trademark protection would also not be copyrightable. It's important to know that you can have overlapping copyrights in just one work. So, for example, with music, when you hear a song on Spotify or you hear it on the radio, there are two copyrights that are implicated in that case. You have the sound recording, which is the recorded music that you're listening to, and you also have the musical composition, which is the underlying musical work. That's the written notes, lyrics, anything about the song that's not being recorded directly. So in that case, you have two separate copyrights, and there could even be separate copyright owners. For example, if somebody hires a songwriter to put together the song and then the recorded artist is different than the songwriter. And let's talk about when protection begins. So copyright protection is automatic. You don't need to register it to receive copyright protection, and it begins as soon as an idea is fixed in a tangible medium. So for example, if you are writing a song, the second that you write out the song, the lyrics, the notes, that's when protection begins. If you are recording it for the musical composition, if you're recording it, the second that you go in and you record that track, that's when it begins. Same with writing a short story, filming a short, as soon as it's fixed. The length of copyright protection really varies, and it depends on several factors. I'm going to give a brief overview. I'm not going to get fully into it because I think we would be here for at least 3 or 4 hours in that case. So, for most works created after 1978, copyright protection is afforded for the life of the author plus 70 years. Okay, so as long as the author lives, and an additional 70 years. For anonymous works or works made for hire, the copyright term tends to be 95 years from the year of first publication or 120 years from creation, whichever one comes first. Okay, so we've covered what copyright is, we've discussed what is entitled to copyright protection, and we have a rough idea of when our copyright protection begins. So let's move on to ownership now. And we're going to discuss both initial ownership and the exclusive rights that are afforded to copyright owners. So initial ownership, like we discussed earlier, by default, a work belongs to its creator. If you are the author that created the work, then you are the owner of the copyright, unless you're in a specific situation, such as like a work made for hire situation or joint authorship. And we will talk about that shortly. Copyright owners are granted 5 distinct rights under copyright law. There are 5 rights given to you that are exclusive to you, and only the copyright owner controls these rights. And I don't think I mentioned this before, but it's important to remember that this only pertains to US law. Other territories and countries have different copyright regimes that apply to copyrights in this country. So this is only as far as US law, US works. So the first right, which is arguably the most important because it tends to be implicated in most copyright infringement disputes, is the right to reproduce your copyrighted work. This grants a copyright owner the exclusive right to control creation of the copies of their work. And since copyright infringement tends to happen from people copying work and displaying it elsewhere, it tends to be implicated in most cases. So some examples of this, for example, would be scanning a magazine and uploading that somewhere, recording or, sorry, I messed with the thumbnail and it disappeared. Recording or uploading music or movies onto a website. So torrenting music, that same situation. Pasting a news article into an email, etc. If it's not protected or allowed by law, whether under fair use or due to some sort of license agreement, it might constitute infringement. The second right is the distribution right. So this gives the copyright owner the ability to control the manner in which a work is transferred to others, whether it be by sale, rental, lease, or lending. And this doesn't just allow the copyright holder to prevent distribution of unauthorized copies, but it also allows the copyright holder to control unauthorized distribution of authorized copies. So for example, if you had an agreement with a party where they had the right to distribute your content and then the term ends and they no longer have it, this allows you to prevent that distribution. So some examples of things that might implicate this right would be copying a news article and pasting it into an email that you send to colleagues, uploading a music file to a website, renting software or sound recordings without proper permission. And you'll see it's fairly similar to the reproduction right, and it's because the two things tend to go hand in hand, right? Generally, if you're reproducing content, you're also likely distributing it. Next, we have the public display right, and this provides that authors have the exclusive right to control the public display of works that can be displayed. So, for example, hanging a painting in a gallery that's open to the public, projecting a slideshow at a public event, displaying pages of a book in a classroom or some sort of exhibit, posting copyrighted images on a website or your social media account. It's important to know that there is no, if you are just showing something privately, it doesn't count as private display. So if you own a painting and you have it hung in your own home, or you have a photograph in your house and you have people over for dinner, that's not copyright infringement. You're allowed to display things in your own home. And the public display right is pretty similar to the public performance right, which is the last one we're going to talk about, except that this applies to the display of a work, except as opposed to its performance. Yeah, and at the same time, it also doesn't prevent you from displaying a copy to people who are present where the copy is located. So similar to like the home example we discussed, if you own a piece of artwork and it happens to be hung up in a specific place and someone walks through and sees it, that's not an infringement of the public display right. Next, we have derivative works. So this is the right to modify. It's often referred to as the adaptation right because that's generally how it comes up. So this is the right to create works that involve some sort of transformation to the original. So it could be writing a sequel to a book, filming a spin-off, recording a remix, translating, and this also includes sampling. So if a DJ decides to sample an existing release and they mix a new, they mix a new set and they just try to distribute it, that implies infringement of this right to create derivative works unless the DJ has permission. Excuse me. And it's important to know too that samples, even as short as 2 seconds, could be subject to copyright protection. There's no time limitation here. So let's say that you are putting together a new track and you want to sample like 30 seconds of Ice Ice Baby. Just because it's 30 seconds or 15 seconds or whatever it might be, doesn't mean that it doesn't constitute infringement. There's really no magic rule as far as time. And the last right that we're going to talk about is the right to publicly perform. And this gives a copyright owner the ability to control the way that a work is publicly performed. And there's specific criteria to determine this. So in order to be publicly performed, it has to be performed in a place that's open to the public, or at a place where a substantial amount of persons outside of your normal family and friends are gathered. So if I perform something in my house and I'm having a party to celebrate a promotion or something like that, that doesn't count as public performance. If I rented out a bar and a bunch of people from the public came, then that would count. Or it has to be transmitted to multiple locations. So this performance right applies to all works that can be performed. So things like showing a movie in a public area. I don't know how many of you are from Portland, but one of my favorite bars in Portland is Bar Bar on Mississippi Street. And they're known for displaying movies or performing movies on a slideshow against the wall. So that would imply the public performance right. Even playing recorded music in a restaurant or retail store also implies this right. Other examples could be streaming a live concert online, showing a film at a public event, performing a play in front of an audience. So those are the 5 exclusive rights that are granted to copyright owners. And so far we've discussed what copyrights are, what is subject to copyright protection, how initial ownership is established, and what rights copyright owners have. So next I want to touch on how copyrights can be transferred, because they can be transferred. Just because you are a copyright owner does not mean that that ownership cannot be transferred or licensed to somebody else. And there are certain clauses in contracts that may transfer, otherwise infringe on your rights as a copyright holder. I know that we recently had a Contracts for Creatives workshop as well, where we discovered contracts. So I won't go too in depth, but I want to touch on a few clauses that as a creative, you should keep an eye out for whenever you are entering into a contract that pertains to your intellectual property. So the first clause I want to discuss, or situation I want to discuss, is a work made for hire. A work made for hire happens when a party hires an individual or especially commissions an individual to create a work, and that party that hires that individual to create the work is considered the copyright owner of the work instead of the actual creator. So a work made for hire can be produced in a couple of different situations. First, it could be a work created by an employee as part of their regular duties. So let's say that I am a graphic designer and I work for Weed & Kennedy or another advertising firm. If my regular duties include creating graphic design products and content for Weed & Kennedy, then that work would be work made for hires. And another situation where a work made for hire can be created is when it's created as a result of a written agreement between the creator and a party commissioning it. So if a party's, let's say you're an oil painter and a party's commissioning an oil painting of their dog, that could be a work made for hire as well in specific circumstances. So, sorry, I misspoke. So there are a few things that have to be met in order for something to be considered a work made for hire in this scenario. Please disregard what I just said. So it has to be specially ordered or commissioned by the commissioning party. The parties have to agree in writing that the work was a work made for hire. So if you don't have that agreement in writing, it wouldn't qualify. And it has to fall within one of 9 statutory categories. So as a contribution to a collective work, as part of a motion picture or other audiovisual work, translation, as a supplementary work, as a compilation, an instructional text, a test, answer material for a test, or an atlas. So just regarding my prior example, I think a better example would be if you were creating, some of the scenes for a specific movie, if you're outsourced to film those specific scenes and you have an agreement in writing, then that would be a work made for hire. So in both of these cases, the legal author and owner of the work is the party who hired the actual creator of the work. It's not the creator themselves. Copyright ownership can also be transferred by way of an assignment. So an assignment and transfer is a complete transfer of all rights. However, assignments could also be for partial rights. It just depends on the way that the clause is put together. All assignments have to be in a signed writing, so they need to be signed by both parties. It needs to be in writing. Yeah, and it doesn't have to be for all rights, though generally I would say most times I see assignments, they tend to be permanent and for all rights. Next, we have licenses. So licenses are another form of transfer, except it doesn't impair your copyright ownership. You retain ownership, but you're granting a third party the right to exercise some or all of the rights in there. A license can either be express or implied, and there's some key considerations that you want to take a look at in a contract if you're entering into some sort of licensing agreement. So you want to keep an eye on the term. What's the duration of the license? Is it for 5 years, 10 years, etc.? You want to look at the territory. Some licenses are only granted for exploitation within the US versus in other countries. You want to see if there's the word transferable or sublicensable in there. What that means is that the licensee would then have the right to sublicense those rights to other third parties. So if you only wanted, let's say, party B to have the right to exploit your content, you want to make sure that this language isn't in there. Otherwise, party B could, in theory, license your content to party C for use as they wish. And then lastly, keep an eye out for the exclusivity provision. So some licenses are exclusive, some are non-exclusive. It just means that either the person has the exclusive right to exercise rights or you retain the right to grant that license to other parties as well. And also whether it's irrevocable or not. And then the last example of a situation where your ownership might be affected is joint authorship. So joint authorship happens when co-authors are creating the work together jointly and equally, and you become co-authors unless you make some sort of agreement in writing otherwise. It's important to know that each joint author has the right to exercise any or all of the exclusive rights, those 5 rights that we discussed before in the joint work. So if you have a co-author, that other author has the right to grant third parties permission to use a work on a non-exclusive basis without your consent. They have the right to transfer their entire ownership interest to another person without your consent. And they have the right to update the work for their own purpose. It is important to know that the joint authors have the obligation to account to each other for any profits received from licensing the joint work. Although obviously this could be changed in an agreement. So if you agree that you'll only take 20%, they'll take 80% of the profits. That's how it would happen. But as a joint author, they couldn't just go and license it and then keep all of the proceeds without accounting to you as well. Okay, great. So we've covered what copyright is, what's entitled to copyright protection. We know what our basic rights are. We understand ownership and we understand the ways in which ownership can be transferred. So now I want to touch on copyright registration. So like I mentioned before, registration is not necessary to have a copyright. Copyright protection is automatic, assuming that your work satisfies the points that we discussed earlier. You do not have to register it in order to say that it's protected by copyright. That said, it can be quite helpful for protection and sometimes necessary if you're ever involved in litigation and you're seeking specific fees. Registration is really straightforward. You can do it online at copyright.gov. The process takes about 3 to 8 months, depending on the work and also depending on just the workload at the US Copyright Office. It generally costs at least $50 to copyright a work. The US Copyright Office also has a circular with fees that we can provide later on. But these fees could go up to 150 or more, just depending on the work, and there are a number of factors there. Marking things with a copyright symbol. Registration doesn't give you the right or anything to mark anything with a copyright symbol, and marking something with a copyright symbol does not give it copyright protection if it's not already subject to copyright. It's generally helpful because it announces to the world that you have a copyright in something, but it's not necessary. Okay, yeah, moving on. So let's talk a little bit more about the advantages of registration. So it's pretty simple. Like we discussed, you just go to the Copyright Office. Their website's pretty straightforward and easy to navigate. There's also a number of companies, I believe, that provide assistance with copyright registration. If you need help, those are out there. I personally think that most people are able to register their copyright directly through the government's website, but there are options if you do need assistance. Registration creates presumption of your ownership. It's necessary for litigation. If you're entering into litigation, you need to have your copyright registered. And it's also necessary in order to receive statutory damages and fees in litigation. If you do not have your copyright registered, you won't be able to receive attorney's fees or statutory damages. And lastly, it just makes it easier to enforce your copyright, right? Because you can refer to the registration with the US Copyright Office. Other people can look it up, etc. So I want to talk a little bit about copyright infringement. First, recognizing and avoiding copyright infringement. Best practice is assume that everything you see is copyrighted. Everything on the internet you see is copyrighted. Every song you listen to, copyrighted. Just because something is marked with a little C, the copyright symbol, doesn't make a difference, right? So if you go on someone's website, you really like their artwork, and let's say that you want to use it to make a fabric print or something else, just because it isn't marked with a C doesn't mean that you have the right to use it. Inadvertent copying is very common, but it's not a defense, right? Just because you did not know that somebody had a copyright in something and you copy it doesn't mean that you didn't infringe on their rights. Attribution isn't permission, so just crediting the author isn't enough. And just because you credit the author doesn't mean that you have the author's permission. It's still a great practice, and I mean, I definitely recommend it because I believe the original authors are owed their due credit, but just keep in mind that you also need to get permission. Using somebody else's copyrighted material without monetary gain is still infringement. So if you use somebody else's, let's say you write a sequel to Game of Thrones and you don't make any money off of it, it doesn't matter. That doesn't mean that it's not infringement. It could still constitute infringement. And then lastly, altering someone's copyrighted material is also still infringement. You need to enforce your copyright consistently. So there's no magical rule or formula here that says if you don't enforce your copyright like this, you're going to lose protection. But generally, courts have stated that the enforcement needs to be fairly consistent across the board. And the last thing I want to touch on in my overview of infringement is works in the public domain. So works in the public domain can be used. They're not subject to copyright protection, and so use of them would not constitute infringement. So if a work's in the public domain, it means that the work has either expired or that the work was created before the copyright system. So for example, the Bible is a good example here. The Bible is not subject to copyright protection because it was created prior to our current copyright system. And also, works in the US created prior to 1923 are also generally safe. It's important to know, though, which copyright you're discussing. So let's take Yankee Doodle, for example. I think Yankee Doodle was written in 1755 or the 1800s, something like that. So it's not subject to copyright protection. So if you wanted to do a cover of Yankee Doodle or use it in some other way, you are welcome to do that because it's not subject to copyright protection. But let's say now that 2 Chainz did a cover of Yankee Doodle, and you want to use 2 Chainz's cover of Yankee Doodle, and you're like, this is the perfect song to sing with the opening track in my short that I'm filming. You cannot use somebody else's cover of a work that's in the public domain. So you're going to have to reach out to 2 Chainz and ask him for permission to use his cover of Yankee Doodle. Or similarly, you could use the original song, an original recording, but you cannot use the other recording that then belongs to another owner. All right, so let's talk about addressing infringement. What do you do if you find your work online, if you find that someone has remixed your song or someone has made changes to your artwork or written a sequel to your book, something of the sort? So the first thing you want to do is notify the infringer. So you need to document the infringement however you're able to. If it's online, take a screenshot, save the web page. If it's in public, take a photo of the infringement, etc. You want to verify your ownership and you want to verify that it's actually infringement. So make sure that you haven't granted a right to this person to use it. And then depending on the infringer, if it's, there are certain online service providers, we'll talk about this in a second, who are subject to the DMCA, or if it's an individual, you'll either want to send a formal cease and desist notice, or if it's the former, let's say an online service provider, they likely have steps that you're going to follow online. And when you send that notification, you need to outline your ownership, say that you are the owner and then provide any proof that you have of ownership, provide any required details about ownership, and include a statement of good faith belief of infringement. So say I have a good faith belief that this person is infringing on my copyright because I did not grant them a right. And then lastly, it should be signed as well. Next, you'll want to consider legal options. So if you're able to, we always recommend consulting with an attorney. In certain situations, you might be able to consult with an attorney at OVLA as well. And I think it's really helpful to determine if the matter can be settled without escalation. Litigation is costly, and oftentimes, if you don't have all your ducks in a row, like let's say your copyright wasn't registered prior to litigation, then you might end up in a situation where you can't be awarded attorney's fees or statutory damages for the infringement. Yeah, and there's also another option, the Copyright Claims Board. I'll talk about this a little bit more on the next slide, but it's a good alternative for smaller creators if you're dealing with copyright infringement and litigation isn't an option. And then there's also the notice and takedown process, and this applies more to material that's hosted by an online service provider. So this would be something like a website, a social media platform, web host, streaming service, etc. Those services have a mechanism available under the Digital Millennium Copyright Act, the DMCA, in the US to remove infringing content. The way it works is that you, as the content owner, if you find an infringing work, you send that provider a formal DMCA notice, like we discussed above, and they are required to take down the content within a specific time frame. Online service providers are incentivized to do this because if they comply, then they're granted a safe harbor, which protects them from copyright infringement liability for their users' actions. It's important to know, though, your work is not done when you send the formal takedown notice. The infringer can file a counter notice. So they could file a notice saying that no, they actually do have the right to distribute this. And that also has a timeline attached to it. So if the infringer files a counter notice and you fail to respond, then the service provider would be required to reinstate the content online. Next, it's important to know about statutory damages. So what statutory damages are is that they allow a copyright owner to recover a set amount of money without having to prove actual damages, which can be hard to prove. Actual damages would be things like proving like what were your lost profits from the infringement? How much money did the infringer make off of it? Oftentimes it's really costly to go through discovery to get this information. So that's why statutory damages are in place. U.S. Copyright Act provides for a range of statutory damages. It really varies based on the circumstance, but it starts at about $750 per work infringed to $30,000 per work infringed. Here's the caveat. In order to receive statutory damages, your work has to have been registered before the infringement began or within 3 months of publication. If you don't fall into either of these categories, you will not be entitled to statutory damages. And then lastly, I just want to touch on contracts here. So if the person infringing on your right was a former licensee who's using it outside the bounds of the original agreement, let's say you enter into a contract with Bob for Bob to distribute your recording somewhere, and now Bob is continuing to distribute the recordings after the term of the agreement ended, then Bob could be liable for both breach of contract and copyright infringement. There could be 2 causes of action there. Contracts are also helpful to resolve disputes through settlement agreements or retroactive licenses. And lastly, when you are entering into a contract about your intellectual property, be aware of certain clauses that might affect your recovery or the remedies that you have. So binding arbitration or limitations of damages provisions. And then just a quick note on the Copyright Claims Board, you can find it at ccb.gov. It is a very creator-friendly process and a great alternative to litigation. It costs about $100 to file. It's voluntary, so both parties have to agree to appear. You can't just force somebody into it. And damages are capped at $30,000. Okay. I think we're right on time. I'm pretty impressed. This is the last section. So we've gone over what copyright is, what's entitled to copyright, what are your rights that you get when you have a copyright, who's the owner, and how can you transfer your ownership, as well as what you do if someone infringes on your copyright. The last thing that I want to talk about is fair use and the AI copyright landscape. Fair use is a doctrine in US law that allows you to use a small part of a copyrighted work without the permission of the owner. The intention here is that it allows somebody to use and build on works in a manner that doesn't deprive prior copyright owners. It is really important to know, though, fair use is not a right that you have, it is an affirmative defense. So fair use does not come up as your like original right to use content. It only comes up if someone is accusing you of infringement and you have to provide a defense to that infringement. So it should never be the first thing that you rely on if you're trying to decide if you can modify or do something with a copyrighted work. It's also really tricky to determine. There's no easy way to determine if something's fair use or not. I think that in the past there was kind of this idea of a 10% rule, that if you only use 10% of a copyrighted work, it's fair use. That's not real. It's not echoed by any courts, and I definitely wouldn't rely on that. So it takes into account a number of things: the purpose and character of the use, the nature of the work, was it commercial or non-commercial, the amount and substantiality of use, did you use the full copyrighted work belonging to somebody else or not, and the effect on the market. So if you use the entire content of copyrighted work and people start purchasing your version, or they start paying money to view your version instead of the original work, then that's much less likely to be determined fair use because you're unfairly depriving the prior copyright owner of their rights. And like we discussed, never assume fair use. Always seek professional advice if you're able to. Okay, and AI. AI copyright litigation is a landscape that is very rapidly evolving. I know that OVLA recently put on also a workshop regarding the legal pitfalls of generative AI, and I would really direct people there for a deeper dive into AI just because there is so much going on in this area, but I want to give a quick overview. So, most of the lawsuits that we're seeing concern the use of copyrighted material for training large language models as well as generative AI. We're also seeing copyright infringement claims concerning the output that AI creates. And generally, the legal defenses that we're seeing from AI companies is fair use, that they have the right to use this. So the US Copyrights Office put out a circular stating its current position. I think it was on January 29th of this year. Their points are one, that human authorship is essential to copyrightability. Works that are created entirely by AI are not copyrightable. Second, merely selecting the prompts does not yield a copyrightable work. So even if it's your idea and you're just selecting prompts to create something, that's not a copyrightable work. Lastly, if the work contains both human and AI generated content, only the human contributions are copyrightable. That said, a human can claim copyright for creative selections, arrangements, or modifications of AI generated material, or potentially where the AI acts only as the tool to execute your specific creative direction. Again, I would not rely fully on this because the landscape is very rapidly evolving and there are currently a number of lawsuits in play that might change how this comes out, but that's your general rule of thumb. And then briefly, I discussed this a bit at the outset. There's a few different theories of infringement. So we have seen lawsuits that are alleging infringement by the AI company for the training input. So the lawsuits are saying that the ingestion process, the process of AI taking in information and training itself, is infringement. And generally, the defense is that it's fair use. We're also seeing lawsuits that are claiming infringement by the AI output. So they're saying that if the AI's output is substantially similar to the original copyrighted work used for training, it violates a copyright owner's rights. And then lastly, we're seeing claims for secondary infringement, which basically hold an AI company liable for actions of users when those users' prompts cause AI to generate infringing output. And there's a number of lawsuits that I would recommend that everyone looks into if they want a bit more information about this. They're all pretty recent from 2023 to today, and most of them are still going on. We have Thomson Reuters versus Ross Intelligence that kind of discusses training data, that first cause of action we discussed. We have Bartz versus Anthropic, which was brought by authors against an AI company for using books without permission to train the large language models. This one was interesting. I believe in this one, they kind of split the cause of action into two. And in June, the court issued summary judgment saying that using the books without permission to train AI was fair use if the books were acquired legally. But if the books were pirated, that doesn't constitute fair use. And then the last one is a really publicized lawsuit. It's by George R.R. Martin, Ta-Nehisi Coates, and a number of other authors against OpenAI and Microsoft. It was initiated in 2023, but it's still ongoing. All right, so key takeaways from today's workshop. Copyright applies to original works of authorship that contain a modicum of creativity and are fixed in a tangible medium. All three of those requirements need to be satisfied for something to be subject to copyright protection. Copyright protection begins when works are fixed. Copyright gives you 5 specific rights as the author of a copyright: reproduction, distribution, adaptation, creating derivative works, public display, and public performance. Copyright can be transferred. Ownership can be transferred in a number of ways, whether it be assignment, licenses, a partial transfer, etc. Work made for hire. Registration isn't necessary, but it does strengthen enforcement, and it is required if you escalate to litigation and you need to obtain certain damages or attorney's fees. Be aware of inadvertent copyright infringement. Keep an eye out there to monitor your works for infringement and enforce your rights consistently. Fair use is difficult to determine. Be very mindful about this, and it is an affirmative defense. It's not a right granted to you. And then lastly, AI is constantly evolving. Keep in touch with OVLA and other local resources in order to stay informed and do your own research about AI just because it's so rapidly changing. And then we have some resources here that you can access, like I discussed, copyright.gov, both to register your copyright and also because it is an excellent source of information. They put out circulars fairly regularly that you can review for information. ccb.gov, the Copyright Claims Board, for creators who are open to that sort of mediation, NOLO books, and then OVLA resources. We have a number of different resources. So like Celie mentioned at the outset, you can apply to get about an hour of legal advice from some of the best, most passionate attorneys in Oregon who really just want to be there for creators and authors. We offer workshops in the spring and fall every year, and we have quite a large number of videos and articles on our website.